This is Michael Popok, Legal AF After Dark. You know, it's getting very dark and dim. Donald Trump's chances to be on the Colorado ballot, both for the Republican primary and the presidential election. That's because we found one state that takes the 14th Amendment, Article 3, and its disqualification language for people that engaged in insurrection or rebellion, like Donald Trump, really seriously. And so there is a trial that is starting this week in Colorado that Donald Trump has decided he'd rather it be tried in absentia without his involvement, even though the result could be him being banned from the Colorado ballot. And so we talked about it and analyzed it and broke it down, an underreported story, we think, but only on Legal AF. And we did it this past Saturday. Ben Meiselas, me, Michael Popok, we put it all together and take a listen to where we think that case is going to go.
Let's talk about what our predictions are in Colorado, because these disqualification cases under the 14th Amendment, Section 3, the disqualification clause, they're heating up. You may recall back in early September, a group that is a friend of the show here at the MeidasTouch Network. We've had their general counsel as well as their executive director on our various shows. The group's called CREW, Citizens for Responsibility and Ethics in Washington. The acronym is CREW. They're the ones who brought this petition. They have a track record of being successful in bringing these types of petitions before. And the plaintiffs, the petitioners in this case, if you will, are actually a group of mostly former Republicans or kind of non-MAGA Republicans, which we highlight a lot here on the MeidasTouch Network, that MAGA is not the Republican Party. They've taken over the Republican Party, but it's a group of actual Republicans and prominent ones who basically say that, no, what happened on January 6th was a coup. It was an attempt to overthrow our democracy. It's an insurrection. Donald Trump needs to be disqualified. Just so everybody remembers what Section 3 of the 14th Amendment states, it says the following: no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. One of the arguments, if you even want to call it that Donald Trump made, which is actually a bit of a kind of chilling argument, is Trump argued that as a president, he did not take an oath to support the United States Constitution. I just want you to think about that for a moment. This is from Donald Trump's motion to dismiss brief. He filed multiple motions to dismiss, but this is one that refers to the other brief where it says, the motion to dismiss explains, this is from Trump. This isn't from me. This isn't from the petitioners. This is from Trump, what I'm about to read. The motion to dismiss explains why the President of the United States is not an officer of the United States. And Trump's reply in support of that motion will explain why petitioners' arguments to the contrary fail. The September 29th motion to dismiss also explains how Section 3 does not apply to all officers of the United States, but only those who take an oath to support the Constitution of the United States. As explained there, the presidential oath, which the framers of the 14th Amendment surely knew, requires the president to swear to preserve, to protect, and defend the Constitution, but not to support the Constitution. So Donald Trump's, one of his arguments is that the 14th Amendment, Section 3 doesn't apply to him because he never took an oath to support the Constitution. That should be chilling. That's what they actually are. That's why we go through the legal briefs, not the propaganda, the legal briefs. That's what Trump said. Trump also argued that this involved a political question doctrine, so that it was non-judiciable, so that the judge shouldn't be able to rule. And then Donald Trump also argued that the 14th Amendment, Section 3, was not self-executing and that requires a decision by Congress to exclude Donald Trump and not by a judge like the Colorado judge presiding over this case, Judge Sarah B. Wallace. Donald Trump also tried to file a bunch of other motions on procedural grounds, statutory grounds. He filed an anti-SLAPP motion saying that he had a First Amendment right to, I guess, lead an insurrection, and that by invoking the 14th Amendment, that chills his First Amendment speech. Judge Wallace rejected all of those arguments, said, look, if you want to make these arguments at trial or in post-trial briefing, go for it. But this case is headed for trial on Monday, October 30th. The petitioners are going to put forward a lot of witnesses, and we don't know who all these witnesses are going to be, but I think there's going to be some powerful witnesses because I've seen some of these motions in limine, Popok, where even some of the witness names are for now being redacted. So it'll be curious to see who the petitioners call as well in their case in chief. To your point earlier in the show, Trump's, I think, not going to call any witnesses and just try to make the legal arguments about the ones that have already failed, but try to make those to the Colorado Supreme Court. And ultimately, I think these disqualification cases go to the United States Supreme Court on an expedited basis, and they'll all kind of get consolidated. And the United States Supreme Court will probably be have the final say in it. One of the interesting things here too that the court found in its order is, look, this is the Colorado Secretary of State. Colorado Secretary of State is compelled to remove people who don't satisfy the constitutional requirements. The same way if someone was not born in the United States, the same way if someone doesn't satisfy other, requirements, that's what the Secretary of State's job is under Colorado law. So even setting aside a declaratory relief type framing of a lawsuit under just constitutional grounds, the court was saying too is this is a Colorado state obligation, and other states have similar types of obligations. So I know I somewhat cannibalized that topic, Popok, because you were interested. I know we got to speak about what's going on in D.C., which I know you're licking your chops.
I'll contribute to Colorado. The judge in her order denying the motion to dismiss, setting the case for trial on Monday, had a footnote in her order which gave Donald Trump the way out. It's just not available to him. Donald Trump's ultimate argument is Congress can take away the disability related to the 14th Amendment and allow him to run for office. And she basically called his bluff in one of her footnotes, and she said, sure, you could do it now. Right now, Donald Trump, if you had the numbers in your favor, which he doesn't, if you can get 2/3 of the House and 2/3 of the Senate to take away the disability, even in advance of the trial on Monday. She said, I don't really want to do this case. She said in the beginning, there's some cases that judges really would rather not do. I have an obligation to do them. But if you think you can get 292 votes in the House, a House that the majority couldn't even get a speaker for about a month, and 67 votes in the Senate, we don't have to do this trial. Now, that was sort of a mean, I was mean in a good way by the judge, because Donald Trump knows he could never get 292 votes or 67 votes, 2/3 in each house related to this. The whole battle here between what I always see time and time again, I'm not sure who the lawyers are for Donald Trump in this one, but they're equally poor, whoever they are, because they're constantly doing unforced errors, telling the judge cases stand for propositions that they don't stand for, telling the judge that there's legislative history that supports them when it doesn't, telling the judge that there's law review articles by right-wing Federalist Society people who have changed their mind and have decided that Donald Trump was right all along, that only the Senate and the House can remove him and not a Secretary of State of a state or a state. And that's wrong. And it's just so easy for judges and their law clerks who help them do the research to take the cases that Donald Trump cites and easily dispatch them as not being credible, reliable. That's the number one thing that kills a lawyer like you and me when you're an advocate in court, when you lose your credibility and when a judges can't trust a word you say not just Donald Trump here, but his lawyers in their filings about what things say and what things don't say. And the judge says, yeah, you're giving me all these constitutional statutes and electoral act law about the Congress and their counting votes and who's allowed to be the president on certificates of election, has nothing to do with the 14th Amendment and whether it's self-actuating, meaning whether it has to go through an act of Congress or not. And it obviously, based on the history here, it doesn't have to go through an act of Congress, nor does it require a criminal finding, a trial finding that he was an insurrectionist or a rebellion against the United States. That's why he doesn't say convicted of a crime, convicted of the following. It's just that he did the following, and that's based on evidence. Now, I've seen the interview with the Secretary of State for Colorado, and she's very clear that she believes that Donald Trump should not be on the ballot and that he was part of the insurrection. And she's also called him out for not even attending his own trial on Monday when it matters most, when the chips are down. But this trial, this bench trial, with all the weight of the evidence that's going to be presented on the scale, and the scale here is not beyond a reasonable doubt. The scale here is preponderance of the evidence. All the evidence is going to go to the plaintiff's side that's trying to ban him from the ballot, from being on the ballot. And so based on the rulings that have already been made by this judge leading into the trial, although sometimes you can't use those totally as predictors because they're on individual issues, I think she's very open-minded. I think Trump's not going to present a shred of evidence. I think the other side is going to put on their evidence. And she's already, as a judge, crossed the Rubicon to decide that she can and has to, as a judge, decide this issue. It's not a political question that has to only be decided in Congress. It's something, once she crossed that barrier and declared off the motion to dismiss that was just filed, that she, as a judge in a black robe, can make the decision. Now, hearing the evidence, I would be shocked if she didn't conclude at the end of that week or whatever it's going to take that Donald Trump did commit rebellion and insurrection against the company and should be invalidated from being on that ballot. I mean, she actually said in her order on issues about, because they tried to handle it on a motion to dismiss the Trump side, he didn't commit rebellion or insurrection. She said that'll be left for trial. I mean, it was just like a chilling one-liner in her order. So, a lot of these other ones got dismissed. People might be thinking, what about the one in Florida? What about the one in Michigan? A lot of them died because they got filed in federal court and federal judges were like, nope, we don't see this. We don't see standing. We don't want to take this case. That's fine. But this state court judge in Colorado, with her Secretary of State, as the person that's is going to be compelled to do something or not here, she's ready. And I don't know about you, Ben, I'd be shocked if she doesn't, after hearing all the evidence, rule against Donald Trump and keep him off the ballot, meaning it'll have to go to the Colorado Supreme Court and maybe to the U.S. Supreme Court after that.
And the timing of when I think it will go to the United States Supreme Court is interesting as we go to our next topic, which is the March 2024 federal trial in Washington, D.C. for Trump's attempt to overthrow the results of the 2020 election, because I am supremely confident that Special Counsel Jack Smith is going to secure a guilty verdict in that case. So as the Colorado case, which I also agree, Popok, I think the judge is going to find that Donald Trump engaged in insurrection and is disqualified. I think that ruling will be stayed pending the appeals process. And then at some point, that appeals process, which we all know the wheels of justice take slightly longer than we would all like it to here on the MeidasTouch Network, at some point that then intersects with the March 2024 federal trial in Washington, D.C., where a guilty verdict there cannot necessarily be brought in as new evidence in a trial that's already been completed in Colorado. But certainly on appeals, it would be a compelling thing to request the United States Supreme Court take judicial notice of that there was a guilty conviction in a federal prosecution of Trump's attempt to overthrow the results of a 2020 election. So as Popok and I think through these issues, as experienced litigators and practitioners, we also think through not just what's happening today, but what's going to happen 3, 5, 7 months down the road. And we want to impart that upon you as well. So you can start not just planning on what's happening next week, say with the Trump kids going to testify, but what's going to happen in 7 months, what's going to happen in 9 months. And we try to give you the best data available for that.
All right. That's an example, a clip, a taster, an appetizer for the Legal AF podcast, the leading podcast of its type at the intersection of law, politics, and justice, U.S. style. And we do it here on the MeidasTouch Network, on this YouTube channel exclusively. And then we put it on all the audio podcast platforms that you can find. We're usually the #1 YouTube live that night, Wednesday nights at 8 p.m., Saturday nights at 8 p.m. We'll get between 17,000 and 30,000 people watching us record and being in the chat with us, let alone when it finally, goes into the library and on the regular platforms. If you know about Legal AF and you saw the episode, welcome back. If you haven't seen the episode or don't even know what I'm talking about Legal AF because you're into other MeidasTouch podcast and programming, or you only know their website, welcome. Take a look, take a listen, tune in for our full podcast. Get it on audio platforms from Google to Spotify to Apple and wherever else you want to get it. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.